No end to the bell, the unwanted gift that keeps on giving. Injunction refused. As many feared, Mr. Justice Mould has refused EFDC's injunction to close the Bell Hotel. Perhaps naively, I believed it could go either way, and I held out hope that common sense would prevail. But no, the judge does not accept the injunction is necessary. It is not just and convenient, he says in the hearing notes. Does it need to be convenient? He does not accept the council's position that the site has undergone a significant enough change of use to close it on planning grounds. He respects that position, he says, but adds the breach is far from being flagrant. Nor does he accept that the change of use poses a significant enough hindrance or danger to Epping residents. This is in spite of one asylum seeker convicted of sexual assault against 2 people, another convicted of assault and battery against 4 people, and another charged with 2 counts of arson. Effect on the local area can be taken into account when deciding on planning disputes, but in his eyes the effect is not significant enough. It is limited, he says, concluding, "This is decidedly not a case resulting in serious planning or environmental harm." First and foremost, the judge was ruling on whether the injunction was justified, but obviously in doing so, one has to consider the basis on which it was issued. Mould's ascertainment of this, detailed in the hearing notes, weighs up various factors. It really does seem to be a case of any excuse, in my opinion. Chiefly, he seizes on the council's previously weak approach to the asylum hotel. We have the obvious landmine of the unprocessed change of use application, which Shamani Hotels made in October 2022, but which EFDC left in limbo. Somani themselves withdrew it in March 2024 as their Home Office contract was supposedly coming to an end. Indeed, such applications are required to be decided on within 8 weeks, so the time elapsed had voided it anyway. The judge leaps on this as evidence that the council was not serious about the change of use issue, or not confident they had a case, because if they had been, they would have processed it. This was obviously going to happen. Mould characterises the injunction as a rushed attempt at a quick fix, before other avenues had been exhausted. The implication is the council wanted a fast solution when the bell became politically toxic. Before this happened, they weren't so bothered. An injunction, after all, is the nuclear option, because if it's broken, it constitutes contempt of court and can result in jail time. Conventional methods of enforcement have not been taken, Mould concludes. There is some truth in what the judge says here. The council did not take any other enforcement action, such as a stop notice, as well as not processing that application. EFDC discussed it among themselves, we can see in the hearing notes, but did not pursue it. However, all this procedural stuff has no bearing on whether the change of use was illegitimate or not, or whether the hotel presents a public nuisance or danger. The judge deems the council's legal services manager tasked with applying for the injunction had not properly prepared a contemporary record of the reasons behind the decision to do so. This, he believes, suggests it wasn't agreed by planning officers or senior councillors, and that she wasn't properly informed of the facts before she made the application. This is despite records of the issue being discussed and unanimously agreed on during a meeting of the council cabinet. The judge was apparently not supplied with detailed minutes of this, though. It is mentioned that the manager was set to go on leave, the implication being she may have cut corners because of this. It seems like nitpicking to me, I could be wrong, but nonetheless the judge deems it a serious procedural error. The council officer is also criticised for not talking to the Home Office about the injunction decision, this would have lost the element of surprise, and for not caring enough about Somani Hotel's point of view. Indeed, Mould is most mindful of poor Somani hotels and their need to make money. Somani had stated their failing Epping business was only being kept alive by the Home Office contract. They went from a loss in 2020 to a profit of £606,000 in 2021. A line they used was that in order to provide a successful local community asset in the future, they needed the contract to keep them above water. The judge seems to concur with this. Don't you see, folks? We must allow them to house 160 potentially dangerous men in a quiet English town near 5 schools, or we'll lose a hotel that was shit anyway. In my own view, Somani are a treacherous firm cashing in at the expense of the country, simply because their previous business model sucked and could not compete in the free market. Somani is a Muslim Indian name. 4 with that name are offices on Company House, so you might infer from that they don't have much loyalty to the country. Epping residents would not care less, and indeed would be pleased if this firm were to go broke. Perhaps another company might make a better job of running a hotel. Something Mould mentions repeatedly is that the contract is temporary, which mitigates the unorthodox usage. Given that the Bell has been housing asylum seekers on and off for half a decade, serving the function for 33 months in total, you'd be forgiven for doubting that temporary status. The judge is satisfied the contract will end in March 2026. Don't worry, people, it's set in stone. It's not like the boats keep coming, is it? I'm glad he has confidence in the word of Yvette Cooper and Shabana Mahmood, because somebody has to.